Okay, and then Will's just gonna stay an attendee.
Yeah, unless he, and he can, if he wants to comment, so I'll just pick him up if he sends a
Okay.
message.
Yeah.
Keeps coming.
If I start sharing my screen now, is that fine?
Yeah.
And then,
It's all on for you, yeah.
okay.
Okay.
Oop. Maybe I'll wait.
Well, do you usually start right at 6, or do you give them 1 or 2 minutes to get going?
Um, Usually at 6.
Okay, we'll start. Oh, it's 6 right now. So we'll go ahead and get started. We will go on the record now. The time is 6 p.m. This is the hearing for Deschutes County file number 247-22-000-792-PA and 247-22-000-793-ZC. Comprehensive plan amendment and zone change request. The applicant has requested approval of comprehensive plan amendment to change the designation of the property from agricultural AG to rural residential exception area, RREA. The applicant also requests approval for a corresponding zone change to rezone the properties from exclusive farm use, EFU, to multiple use agricultural, MUA 10. My name is Alan Rappelier, and I am the hearings officer in this matter, and we are holding this hearing in part through electronic means. Before we turn to the particulars of the hearing, I would like to turn these things over to Ms. Vickers to describe how the electronic process works. Ms. Vickers?
All right, thank you. Good evening. For the record, my name is Rachel Vickers, and I'm an associate planner with the Deschutes County Planning Division. The item before the hearings officer is a planned amendment and zone change. I'll begin by explaining how the hearing will be conducted and how members of the public can testify. Then I'll turn the hearing over to hearings officer Rapelier for his hearing instructions. I'll follow with my oral staff report. The applicant will make their presentation, and then the public will be invited to testify. The applicant will be given an opportunity to present any rebuttal testimony, and lastly, staff will be afforded an opportunity to make any closing comments. Tonight's hearing will have a hybrid format, allowing for both in-person and remote participation. The order for testimony will be as follows. First, the applicant will present their evidence. Then those in support will be asked to testify. Next, those in opposition, and then anyone neutral to the applicant's request. And lastly, the applicant can present rebuttal testimony if desired. Before starting your testimony, everyone will be asked to provide your first and last name and your mailing address. The hearings officer will prompt you if you forget, but the county needs this information before you start your testimony. For everyone joining us in person and wanting to testify, staff will ask interested persons to raise their hand, and then staff will call up each person one by one for their testimony. Please come up to one of the tables and be sure to speak into the microphone to ensure your testimony is picked up by the audio system. Also, staff requests that you write your name and contact information on the sign-in sheet. For those attending using Zoom, there are two categories of participants, attendees and panelists. Currently, everyone except the hearings officer and county staff are attendees. As an attendee, your audio and video are not recorded. When your status changes to a panelist, your microphone and video will be active for everyone to hear and see you. This is an important distinction because anyone wishing to testify via Zoom will be promoted to a panelist so that your audio and video can be recorded. For those joining us via Zoom using a computer, there will be multiple times during tonight's hearing that the hearings officer or staff will ask you to use the raised hand feature to communicate with staff. This feature is available for attendees and panelists and can be found in the center right of your screen or device. You will need to click the raise hand button when prompted. If a large number of people have their hands raised, we ask that you keep your hand raised until you are promoted to panelist or asked to put your hand down. Once you are promoted to a panelist, you'll see a button for your microphone in the bottom left corner of your screen. If you press this button, you'll mute or unmute your microphone. I point this out because during your testimony, you may want to confer with your legal counsel or client. To the right of the microphone button is one for video. By pressing on this button, you can black out your video. Again, during your testimony, you may want to confer with your legal counsel or your client. For those joining us via Zoom that have called in by phone, there will be multiple times during tonight's hearing that the hearings officer or staff will ask you to use the raise hand feature to communicate with staff. This feature is available for attendees and panelists and requires you to dial *9 on your keypad. When prompted to raise your hand, you will need to dial *9. Once you are promoted to panelist, you can mute or unmute your microphone by dialing *6. In addition to oral testimony, you may want to submit written testimony at tonight's hearing. If you are in person, please submit your written testimony to me prior to beginning. If you are participating remotely, please submit your written testimony via email. My email address is on the screen. Should the county's internet connection be interrupted, we will attempt to get back online as soon as possible. If this happens, please give us a couple of minutes to reactivate the public hearing before you attempt to link or call back in. If your own connection gets interrupted, please attempt to join back using the same link or phone number you used initially. With respect to oral testimony, the hearings officer and staff are responsible for ensuring a respectful and orderly hearing. Any testimony or behavior which is inappropriate will be addressed and may result in that member of the public being removed. Are there any objections to the format of the hearing? If you are attending remotely and have an objection, please use the raised hand function. Again, if there are any. Seeing none, I'll turn it over to Hearings Officer Rapelier.
Great. Thank you, Ms. Vickers. As Mrs. Vickers described, we are following the normal hearing procedure for the county code. and I will provide sufficient opportunity for everyone to participate at the appropriate time. I ask for your patience as we make sure we get through each of the steps just outlined. Before you begin your comments, please state your name. This would be very helpful for me. And if you would spell your name, even if you think it's quite simple. This application is to be considered through a quasi-judicial process. I will consider only the factual evidence that is in the record. I will then apply those facts to any relevant provision of the county comprehensive plan and land use regulations. The standards and applicable criteria relevant to this hearing were identified in the public notice announcing the hearing. They are also set forth in the staff report. Public notice and staff report are posted on the county's website. They're also available directly from staff upon request. It is important that you direct all your testimony to the standards and applicable criteria. If you believe a criterion applies that was not listed, you may address the unlisted criteria. However, I urge you to also explain why the criterion must apply and to do so with specificity so that other participants may respond and so that I can address the issue in my decision. The failure to raise an issue with enough detail to enable me or other participants to respond precludes your ability to appeal that issue to the Land Use Board of Appeals. Also, the failure to raise a constitutional or other issue related to any proposal the conditions of approval with enough detail to allow me to respond to the issue in my decision precludes an action for damages in circuit court. As I just noted, I serve as the county's hearings officer in this matter. In that role, my job is to be a neutral decision maker. Thus, while I have a contract with the county to serve in this role, I am obligated to remain impartial, and I do not represent the county's interests or interests of any other participant. To that end, I'll state to the record that I do not have any relationship with the applicant, and I am not aware of any connections I have with any other participants in proceedings that would prevent me from remaining impartial. I have communicated with staff, but only to discuss the particulars of today's hearings and have not the substance of the application. I do not have any ex parte contacts to disclose, and it is my obligation to preside over this hearing in an efficient manner. The order of the proceedings will be as follows. Staff, then the applicant, then those in favor of the application other than the applicant, those opposed to the application, those neutral to the application, rebuttal by the applicant, staff comments or questions to staff by the hearings officer. Before we begin, does anyone wish to challenge my ability to hear this matter or to challenge the county's jurisdiction over this matter? Seeing none. Continue.
All right, thank you. The subject property is approximately 40 acres in size and located about 1 mile east of the city of Bend. As noted by the hearings officer, the applicant requests approval of a comprehensive plan amendment to change the designation of the properties from agricultural to rural residential exception area. The applicant also requests approval of a corresponding zone change to rezone the properties from exclusive farm use to multiple use agricultural. No Goal 3 exception is proposed. The applicant has provided evidence in the record that the property does not contain farmable soil and is incorrectly designated as agricultural land. In addition to the burden of proof, the applicant has submitted soil studies from Red Hill Soils and a traffic study by Transite Consulting, LLC, in support of the proposal. In response to the notice of application, staff received 2 comments in opposition. One comment questioned the proposal's ability to meet the relevant criteria for approval. The second comment opposed the establishment of a commercial use on the property in the form of a drug rehabilitation center. Staff notes no development is proposed at this time. Staff further notes that we received 2 additional comments today, one earlier this afternoon and one at about 6 p.m. today that was supplemental materials from Landwatch, both in opposition. This concludes staff's report. At this time, staff is available for questions from the hearings officer.
Excuse me. So now we're going to begin the oral public testimony part of the hearing. So I'll ask for the applicants and their testimony, and please state your name and address for the record. Oh, and Ms. Vickers, I'd like to be able to, of course, see the new submittals from that were filed today. I haven't seen those.
Yes, those will be added to the record and I can send them to you. Thank you.
Great, thank you.
Good evening. For the record, my name is Tia Lewis. I'm an attorney for the applicant, and my address is correctly stated on the application materials as well as the front cover of the staff report. I'm going to be brief and try not to duplicate staff's presentation. I do have a short PowerPoint presentation if we can cue that up. There we go. Thank you. So as Rachel mentioned, the subject property is 40 acres, and it is, let's see if I can, there we go. Subject property is 40 acres, and it is approximately 1 mile from the city of Bend. It is adjacent to MUA 10 land to the north. There's a big block of MUA 10 land to the south. All of the property between the subject property and the city limits is MUA 10, and it's less than 1 mile from an additional parcel of land that's going to be included into the city of Bend. It's even closer to that property, and I have another slide about that I'll talk to you about in a few minutes. So, and there's also another slide that shows a bigger picture of the surrounding zoning, but I was trying to hone in on what exactly is going on in the area here. Again, there's a large block of MUA 10 land to the northwest, as well as another large block to the northeast, and again, another large block to the south, as well as a little bit further south, there's RR10. The subject property is adjacent to the MUA 10 zone. If you can note, I'm sorry I can't point with this setup, but the Stevens Road track is that yellow piece. That's inside the Bend UGB, but not annexed to the city of Bend yet. So the existing land use pattern, the predominant use in the area is rural residential. There are properties within the EFU zone to the north. Those are small hobby farms with roughly about 6 to 20 acres. And then to the northeast is the Arrowhead Acres subdivision. That was a subdivision platted in the early 70s before the county had zoning. It's a 49-lot subdivision. All of the lots are less than a half an acre. And then what you can see on this map is what's called the Somerset subdivision. It was platted in 1976. There's about 25 lots in the Somerset subdivision, and again, those range in size from a half acre to 2 acres. All of these residentially platted subdivision lots are in between the subject property and the city limits and the UGB. And then we do have a large neighbor to the east. That property is not in farm tax deferral, I don't think, but the neighbor did write us a letter in support of the application, as well as all of the adjacent neighboring properties to the south also wrote letters in support of the application. Those are exhibits 12 and 13 in our application materials. So this slide is designed to represent what's going on the urban fringe of the city of Bend. The subject property is, you can see sorry this map is so small, but subject property is outlined in red, right close to the bottom of the map, very close to the large red block that is RR10 land, just to the northeast of the large, just to the northwest of the large red block is the subject property. But if you can see the Bend city limits as they go along the eastern city limits boundary, all of the lands along the urban-rural fringe are being changed to MUA 10 zone in order to make way for the next UGB expansion. And this is consistent with the county's comprehensive plan policy, which provides for the rezoning of non-productive agricultural lands. So this is just a little bit of what, so I put this slide on here so that you can see the Stevens Ranch master planned property. That is inside, that colorful property is inside the city limits. This whole big 640-acre block was formerly a part of the Division of State Lands holdings that they sold. Well, the DSL actually still owns the eastern half, but the western half they sold, and it got brought inside the UGB and annexed to the city of Bend. It has received master plan approval for 237 acres of residential, 45 acres of, or 46 acres of commercial, 93 acres of industrial, and within those zoning designations, there is plans for a park, open space, and an elementary school site. Again, this is approximately 1 mile from the subject property. And this property went through the same process, this DSL property went through the same process that we're applying for here today, which was a non-resource zone change. They did it in 2 blocks back in, they did the west half, I believe, in 2013 and the east half in 2018 to take it to an MUA 10 zoning designation in order to facilitate its eventual inclusion into the UGB and ultimately the city limits. So the next slide is the.
Can you hear me?
Yeah. Yes. Go ahead.
I'm just curious. There was legislation involving this property. Did that do anything to the zoning? I briefly saw that in the record.
Yes, sir. So the legislation, that's this slide here. The legislation involved the eastern half of the property. So the western half of the property, DSL sold, and it came inside the UGB during Ben's PAPA, it's regular,
Right.
The regular course of UGB expansion.
Legislation that brought it into the UGB and resolved the issue of rural versus, urban versus rural.
So the legislation that brought it inside the UGB was only for the western half, and it was House Bill 3318, as indicated on this slide.
Okay, thank you.
Yeah, you bet. So, yes, that legislation brought it inside the UGB, the 261 acres of the other half of the property, and it's currently going through a master planning effort. It will be similar to the western half in terms of being a complete community. There will be residential zoning designations as well as commercial zoning designations. Probably not industrial, since the eastern or the western half has 93 acres, so it'll probably be more residential and commercial, but the city of Bend is currently in the process of master planning that, and they did not have any master plan designs yet for me to include. So this is a slide demonstrating all of the most recent non-resource designations on that comprehensive plan map that I showed you earlier, where you saw all those big yellow MUA 10 properties. These are a lot of them right on the urban-rural fringe. Our property is outlined in black, and those ones in red are all of the recent non-resource zone changes that have been going on the eastern city limits on the urban-rural fringe. That the first one identified East Side Bend. That one occurred in 2019, and that was on the corner of Highway 20 and Ward Hamby. And then the Porter Kelly Burns property, that one occurred in 2017, and that one currently is also the subject of a piece of legislation that brought it inside the UGB for a affordable housing project. Hayden Homes is developing that with a full, I think it's a full affordable housing project with private dollars. And then the COID property, it was changed to non-resource in 2022. Again, that's state of Oregon. That's the biggest block there that we just talked about. That was done through 2 decisions in 2013 and 2018. And then another one, Markin, was done in 2023. That one just went before the Deschutes County Board in January. It went for a hearing back several months ago. And then there's the final one, Te Amo Despacho, and that one's again right on Highway 20 there. And that one has gone through the hearings officer's decision and is scheduled for the board in the spring.
If I interrupt again, the Markham decision, has that been heard by the Board of Commissioners yet?
The Markin decision has been heard. It was heard on January, I believe it was 20, I can look it up for you if you want the date.
Do they have a decision out on that one?
No, they had a post-hearing record period, so the
Okay.
the hearing was on the 23rd, and the post-hearing record closed in early February, so the board decision is probably due in about 30 to 45 days.
Well, I'd be interested in seeing that decision, which might be helpful in this decision, so.
Yeah, absolutely. And there are, all the other ones other than Markin do have board decisions. And I have all of the file materials as well as the file numbers, and the ordinance numbers are referenced in section 5.12 in the legislative history section of the Deschutes County Comprehensive Plan. There's some significant board decisions in this area, particularly hold on one second. Look for that one I'm thinking about. There's a Swisher one that I actually don't have referenced on here, which is one of the better board decisions. And they issued a lot of really detailed findings, which we can submit into this record.
I saw that Markham one there was some, really decent arguments back and forth on that one. And,
yes, sir.
There is another case out there that had the Central Oregon Land Watch weighing in on it and addressing the fact, the issues that might be useful for the hearings officer to see.
Yeah, absolutely. That Markin decision is probably the closest one. The one you may be referring to, there was a non-resource designation for 710 acres up near Terrebonne, and that one generated quite a bit of testimony and opposition. It's significantly different than this particular one, so I think the Markin is probably the more relevant one. But there are, and as well as the Swisher one.
Markin seems pretty similar.
Markin, absolutely, yes. Although there was history of farm use on the Markin property and not on this one, so it is different in that respect.
Yeah, I did see that. Thank you.
You're welcome. So then I put the rezoning standards up here simply for the fact that I felt like I needed to include some law in this presentation, but I don't want to, these get kind of tedious when it comes to presenting these in slides, so I don't want to spend an enormous amount of time going over each one of these other than to just...
I don't think you need to. I'm familiar with the law.
Excellent, thank you. I can point you to the places in the burden of proof statement where we address each one of these if you like, or I can just leave you to read through it.
I read through the staff report and your application materials. I thought they were thorough. I'll have some questions later on, but I don't think you need to address them specifically.
Okay,
Certainly
perfect.
feel free to.
Thank you very much. Given your position as a recovering planner and Crook County guy, I figure you probably are pretty familiar with this stuff.
I'm familiar. My parents used to live out, I guess part of disclosure, my parents used to live east of Bend, so I'm familiar with the area out there too.
There you go. Very good. Okay, well then I won't belabor these rezoning standards. I believe that the only evidence in the record supports substantial evidence that we've complied with these. So I'm going to move on and let you ask your questions at the end if you prefer.
Please.
Okay. So then this slide was meant to represent for me, again, the state law in this regard, and I didn't put it all up here because it does get a little tedious, but as you know, the state law is primarily the area in which agricultural land is regulated, and that includes the Oregon Revised Statutes, the Oregon Administrative Rules, as well as the statewide planning goals. And agricultural land, as it's used in Goal 3, is defined at OAR 660-033-0020 as lands classified predominantly classes 1 through 6 in Central Oregon. And so we sought the non-resource designation for this particular piece of property because our soil study has demonstrated that we do not have a predominant class 1 through 6 soils. In fact, we have over 58% class 7 and 8 soils. And in addition to just the soil, the agricultural definition, there are some other factors which the administrative rules set forth that need to be complied with or considered when determining whether or not a piece of property is resource land. Those include the suitability factors as well as the farm unit rule in the Oregon administrative rules. And in the burden of proof at pages 21 through 33, as well as in the staff report at pages 24 through 37, those suitability factors as well as the farm unit rule are addressed. And I do have, I have some conclusory remarks, and then I also have some remarks designed to address the last-minute filing by 1,000 Friends. I have not seen the last-minute filing by Central Oregon Land Watch, so I'm not prepared to address that orally, but I will address briefly the 1,000 Friends comments, and then would like to reserve an opportunity for rebuttal. To the extent that there is no opposition testimony, I would like to make my closing remarks during my rebuttal period if the hearings officer would indulge me.
I have no issue with that, and certainly I'll have time to answer the most recent comments we got in. So are you, I'm not quite sure I understood, are you going to respond to the 1,000 Friends letter at this point or later?
I'm going to respond briefly to the 1,000 Friends letter right now, if you let me, and then I'll give closing remarks later.
I'm hoping you did say that. All right, thank you.
Okay, so I don't think you've seen this yet, but it really just raises two issues. One issue, it says that we haven't demonstrated that the land is not agricultural, and then it says that we need a Goal 14 exception. And so I'm going to address these again just pretty briefly. I also wrote out a written response to them in the hopes that we could avoid this post-hearing briefing, the fun part of all this if we can. So I also will submit that tonight, depending on the amount of testimony we get. But with regard to the agricultural land issue, we have submitted an Order 1 soil survey which demonstrates that the property is predominantly Class 6 and 7 soils, as well as we've addressed all of the suitability factors. But one of the things in 1,000 Friends letter that I thought was important to point out is they take the farm unit rule and argue that because we have some Class 6 soils on our property, that we need to address the farm unit rule, which is you're probably pretty familiar with it. Trying to find the exact citation for it. It's at OAR 660-033-0020 sub 1 sub B. And this argument is really misplaced. The farm unit rule applies when you have a farm unit and when you are taking a portion of that farm unit and seeking to rezone it based on its soil classification. You have to have a farm unit in the first place for the farm unit rule to apply. And we don't have a farm unit. We have no history of farm use on this property currently or in any recent past that we're aware of. And so to apply the farm unit rule to a piece of property simply because it has some Class 6 soils, it pretty much it removes the predominant soil test that is the definition of agricultural land. So I think that 1,000 Friends' argument about the farm unit rule is improper. And then secondly, as far as a Goal 14 exception, a Goal 14 is implicated only when we have urban uses of rural land. And in this case, we're asking for a MUA 10 zoning designation. Even if a cluster development were developed on this 40 acres, the result would be 7.5 units to the or 1 unit per 7.5 acres, which is in no way an urban use. And in fact, the county's rural designation has been acknowledged by DLCD as in compliance with Goal 14. So we're not asking for any sort of comprehensive plan zoning designation that would allow a density that hasn't already been acknowledged as in compliance with Goal 14. So that'll conclude my remarks.
Follow-up questions about this, and so I'm glad you're addressing it.
Okay.
So the MUA 10 has been acknowledged as a rural designation, is that what you tell me?
The rural, it's not necessary, it's the designation of the rural residential exception area, which it includes MUA 10, it also includes RR 10. It has been acknowledged as in compliance with Goal 14. So that does include the MUA 10 zone, but it's that exception area.
So when the county adopted those zonings, the state didn't raise a fuss about them being urban instead of rural.
That's correct.
It was acknowledged, basically. Yes.
Yes, sir.
Oh, okay, that's good. That was one of the questions I had. Thank you.
You're welcome. So then I'll just save my closing remarks and any rebuttal until after the public testimony. Oh, I do have my client here that would like to testify briefly.
Please put him on or her on.
Thank you. Just sign in on that sheet and then state your name and address.
Is the person in the room with you, or?
Yes, I am. Sorry, I was signing in, sir.
Oh, okay. I don't have a video, so I can't see what's going on.
Gotcha. I wasn't looking up. Yes, my name is Kevin Griffin, Griffin. I live at 21900 Rastovich Road. I purchased this property 12 years ago when I retired as a firefighter and took it as my home for just personal use with some little bit of water. We have 5 acres worth of water for the 40 acres of property. Has a very large rock outcropping through the center of the whole property. I've done a little bit of little gardens for myself, but nothing that can make any money. I have a good relationship with the Rastovich farm, which is bordering both my south and my east fence line. They've brought over equipment and tried to clear out a 4-acre patch for me to grow hay, or at one time they were going to attempt to do hemp there, which didn't work. They lost several $100,000 the first year trying to do that. So at this time, the property has never been in farm deferral. I looked up the records from the Williams family, which I purchased it from in an estate sale, and they had never had it in farm deferral ever as well. So once we found out with that small acreage and the small acreage of water that we had a study done, and it found out that it would cost more for me to farm that small plot and try to get hay or anything that would possibly grow within our season there, because I offered that for free to the Rastovich farm if they would do the work to keep my water rights going for that property. Otherwise, it's just a big sand lot. The last 2 years, I've received no water at my property because I'm not farming. I had my weir shut off, and my weir dead ends at the end of a vein with the Rastovich property through Arnold Irrigation. So any extra water, even though I could not assign it to them, went through their weir to try to get their fields for their cattle, and that's what they have over there. They don't grow anything but grass, but the last 2 years they've had to feed their livestock hay as well, just because the reservoirs have been empty. All the surrounding areas, my north fence line, east and south, are exclusive farm use. All of them signed letters in support of me changing this designation. And my west fence line is the Somerset property, which is MUA 10 properties that border my exact fence line. So I am a landlocked square there with no other where to go. So I just wanted to let you know that that's what I've done with the property. I am retired, and I try to keep it so that it's fire safe, but the last couple of years, it's just all sagebrush and rock right now. So we're going to do the best we can, but the water company let me defer the water, they said up to 5 years without losing the rights, so that we could come back this year and try to get the pond working properly and get some water somewhere just for some greenery. But as far as growing anything out there, it's been impossible.
So, thank you very much, Griffin. Mr. Griffin, you helped me with some of the questions about the irrigation rights. So you have 6 acres of irrigation rights? And
5 total for the, 5 total acres for the 40, yes. And it runs through, we're at the end of a vein, and my ditch runs through the Rastovich farm, because I believe 103 years ago when they homesteaded there, that square was attached to their farm. I think there's only been one other owners besides the Williams. It might have been the Vodvics, but I can't be quoted on that one. But that's just the history I've been told with the property and what it is. So the neighbors have tried to attempt to help me to get it to at least stay a little bit green, but we've been unable to grow anything out there. So
what are your intentions to do with the water rights you have?
Well, right now, we're keeping them, because if we get it divided into MUA 10, hopefully we can divide it up for whatever the four plots that would be divided into at one point. We have no plan for subdividing it right now or doing anything of that nature. So, but we also, being still zoned farm, don't want to just give up that right and water in case something changes where we're told we have to farm there somehow. So we're kind of waiting to see what the balance of that is going to be, but we've been just letting our water go to the neighbor's property to help them out the last 2 years, which Arnold Irrigation also wrote a letter of recommendation and stating that that this won't affect any other properties around me. It dead ends on my
line.
land. Yes. Yeah.
I saw that. Thank you.
Yeah. Okay. Thank you very much for your time.
All right, great. Thank you. Ms. Lewis, have anybody else on your side before we go into other people in favor?
No, that concludes the applicant's presentation. Thank you.
Okay, thank you. All right. Is there anybody else in person or electronically would like to testify in favor of this application?
Yes, we have one person in, we have, one. If you could please write your name down and state your name and address for everyone.
I'm writing my name. I guess you can't see me, so.
I can see it this time. Thank you.
Okay. This pen doesn't work very well. There we go. Thanks. My name is Gail Weber. I live at 61638 Somerset Drive, so my property is directly adjacent to the subject property. We're part of the Somerset Phase 1 development, which, just for the record, is 36 lots, and we're all zoned MUA 10. I support the application. We have no objections to it being changed to the zoning that surrounds it. I do want to clarify something for the record, however, if I might. Ms. Vickers mentioned that there was an objection filed against this application with a mention of commercial use. I've read that objection, and I believe it was intended to be filed against a different property, in particular the property located at 61667 Somerset Drive, where there is a proposal pending for the opening of a addiction treatment facility, and I just believe that letter was filed against the wrong property. I contacted that individual and suggested that he withdraw the letter and file it against the property where it was intended to be filed, but I don't think that he has been successful in doing that. Thank you.
All right, that makes sense. Thank you very much for your testimony. And yes, as we heard from Mr. Griffin, he's not planning to do anything different on the property. So I don't think so. I think it probably was a misdirection on that. Okay. Anybody else in favor of the application? Ms. Vickers?
Let's see, we have one attendee online. If you'd like to testify in favor, please raise your hand. Okay, it looks like they do not want to testify in favor.
Okay, then we'll take testimony who are neutral. Anybody out there was either for or against, just wants to have their voice heard in this matter.
Again, online, if you'd like to
Right.
testify, neutral. It looks like the person online does not want to testify neutrally either.
Okay, then we'll take testimony in opposition. Is there anybody who wants to testify in opposition to this application?
There's one person online, but it looks like they are not raising their hand to testify either in support, neutrally, or in opposition.
Okay, so there's no one in the room there, no one online testify in opposition. So we'll give the applicant one last chance to make any statements for the record. And then have the chance to keep the record open, obviously.
Thank you. Could I clarify one thing with Rachel really quick? It says part one. Was there more than one part?
There was two, yeah, they
Okay,
sent,
okay. Sorry. If you could bear with me for one moment, I'm looking at Landwatch's submissions to decide whether or not I need to leave the record open, because I just saw them.
Okay, that's absolutely fine. Take your time.
Okay, thank you. So I do have a written submission that I would like to submit in response to in response to the Thousand Friends comments. They will equally address the comments raised by Landwatch, so I do not believe that we need to keep the record open. I am willing to answer any of the hearings officer's questions if he still had some, or I can just go directly into my closing remarks.
Well, at this point, I guess I'll ask Ms. Vickers, is there anybody else online or in the room who wants to keep the record open or submit any additional evidence?
there is no one in the room, and the one attendee online is not raising their hand.
Yeah, I guess, okay, that makes sense. All right, Ms. Lewis, please finish your statement then.
Thank you very much. So again, I do have one written submission that I'll submit into the record. I think we left off with, hold on one second. In our materials, we had 18 exhibits, so if we could mark this Exhibit 19 for the record. And it's a letter from me to the hearings officer dated February 28th in response to Landwatch's comments of the same date, or excuse me, 1,000 Friends comments of the same date. Okay, thank you very much. So, in conclusion, the present application is a part of a series of applications that have been made on the urban-rural fringe to respect the comprehensive land use planning responsibilities that cities and counties need to conduct in order to coordinate and cooperate particularly for properties along the urban-rural fringe as it pertains to UGB expansions and annexations and activities which occur on the jurisdictional boundaries. The City of Bend's planning period ends in 2028. It takes a minimum of 4 years after inclusion inside the UGB for a vertical development to take place, and only 8% of the population in Deschutes County can afford a home at the median price. It's imperative that the city and county cooperate to coordinate on these zoning decisions to ensure orderly and efficient provisions of services and future UGB expansions to address Bend's historic and predicted population growth, and particularly the lack of affordable and workforce housing to serve our community. We believe that the only evidence in the record supports the approval of the plan amendment zone change, and we respectfully request that the hearings officer recommend approval of this request to the board. Thank you.
All right, Ms. Lewis, I'll let you reserve the chance to keep the record open if I'm going to ask just, I think, a couple questions of staff. And if you feel that those are not adequately answered or raise some concerns, I'll let you rebut those at a later point. I'll give you that chance. So the one question I have on this is this transition, you bring it up, this sort of the transition area. Now, I'm familiar with having zones where you preserve the ability to expand outside of the urban area and get some more density in there. And I was wondering if the staff can assure me that if they do this zoning on this, that this will preserve the ability, once the growth gets out there, that they will be able to, provide a dense and, urban setting. And the fact that they're going to build huge mansions out there won't preclude that.
It might be. Are you asking, sorry, can you rephrase the question?
I guess I'm asking about this, the history of the zoning, that they're asking for. Is it going to be, is part of the idea is to preserve the area for this transition that Ms. Lewis was just talking about?
Yeah, so we have our planning manager who will be elevated, who will be able to address that. He'll
Okay.
be on the screen in just a moment.
Just kind of interesting. There's this big transition going on here. I said I'm familiar with the area, and we're getting a really urban area that the legislature is getting involved with, and we're getting all these parcels put in, and then we're getting this type of urban, rural residential put in. So, as Mr. Groves.
Thank you, hearings officer. For the record, Will Groves, CDD planning manager. You guys hear me okay?
Yes.
Excellent. So, of course, applicant's attorney, Tia Lewis, has excellent experience on this, and I definitely will appreciate her contribution to this discussion. The plan right now is to rezone this to an unrestricted MUA 10 zoning, if I have that correct. And so because it doesn't have an overlay zone and isn't part of one of the city's urban reserve areas, it would not be restricted in this way. And this is true of all the applications that we've seen to date. One of the things that Deschutes County and the city are working on in a kind of a medium term is the exploration of urban reserve areas that would have these types of protections. But currently there is no designation in the county that has the types of protection that you're looking for. It's a concern that we've had in discussions with the city. And unfortunately, there's just not something that has that type of preservation as a county zoning choice at this point.
I can add something to that if I will.
Please.
Yeah. So we would love to be able to go into an urban reserve designation and have inquired at the City of Bend about any urban reserve planning. And the information that we received back from the City of Bend is that it takes so long for them to even get a UGB planned that to try to plan urban reserve, they decided to do away with urban reserve planning and go directly into the next UGB expansion. So the MUA 10 zone does provide lot sizes that limit development in a way that would be suitable for conversion to urbanization. It does not prevent development of, say, for example, a mansion, so to speak, on a 10-acre piece of property, but those lot sizes do facilitate future urbanization when that time comes.
It appears that we've lost the hearings officer from Zoom. I'm wondering if he's having connection problems.
Yeah, we'll give him a few minutes.
Everyone at home, I appreciate your patience. We're working on reconnecting the hearings officer. Again, everyone, thanks for your patience. The hearings officer had indicated at the beginning of the hearing that he might be having internet difficulties and had an alternative hotspot solution that he would connect to in the event that he had connectivity difficulties. So we'll wait a moment for that.
They didn't want the record.
Hello?
They didn't say anything about the record.
Hello?
Hi, Alan.
Can you hear me?
Yes.
Okay, yeah, I don't know what happened. My Wi-Fi seems to be working here.
Okay, interesting. Do you mind continuing by phone?
Oh, we're just about done there. I just had just a little bit of follow-up question on the, on that one issue I had.
Okay.
Glad to have you back, Alan. So I had responded to it, but I thought applicant's attorney, Tia Lewis, had a great answer for this as well. So I'll let her field this one, and you can let me know if you have additional questions.
Okay, great. Thank you.
So I'm not sure where we lost you, but one of the comments that I was making.
Go ahead. Go ahead.
Okay. We had inquired with the City of Bend about urban reserve planning, and because of the controversy surrounding Bend's UGB, it took 12 years to get the UGB expansion. So their appetite for urban reserve planning is relatively low, and given that the planning period ends in 2028, they're just going to go directly into the next UGB expansion and not do any urban reserve planning. But however, the MUA 10 zone does impose lot sizes that will limit development enough that urbanization can occur, even if we have, one house per 10 acres, or if there were to be a cluster and you would end up with the maximum density you could get there is 1 unit per 7.5.
Right. I thought the cluster seems like it'd be a good solution, but okay. Well, that's what I was kind of thinking. I just hoping you'd address it and just to allay my concerns. So I think you answered my question. I appreciate that. I have no further questions, and so I guess I'll leave it back to Ms. Lewis whether she wants to keep the record open for any other issues.
No, I don't believe it's necessary. The materials submitted by 1,000 Friends and Landwatch are the same materials they submit in all of the files, so I did prepare a response, and I believe it's sufficient.
Okay, well then I'll ask staff if they have any final comments, and then we'll close the hearing and close the record too.
Staff has no final comments at this time.
Okay, well then we'll close the hearing, and I will. Oh, the one thing I would like to review, which I think we can take for judicial notice of, is those decisions of the prior decisions of the Board of Commissioners on the similar issues. And with that, I will start working on preparing a decision in this matter.
Excellent, thank you, and I have no objection to including the board marking decision as a part of your record when it does come out.
Okay, great. And one other thing for you, Ms. Lewis, you understand this is not subject to the 150-day mandamus rule?
I do. Does that mean you're just going to sit on it, or are you going to?
No, I have contractual obligations with the Chiefs County to work with diligence, and I will do that.
Okay, diligence.
Okay. All right. Well, thank you very much. Appreciate all the participants in tonight's hearing, and we'll get the decision out for your review. Thank you very much.
Thank you.
Thank you.
Good night.